the November 13th Buncombe County Board of Adjustment meeting to order. Thank you all for being here. I understand there's a little bit of community interest in this case now. It's positive. We're going to go through our normal procedure, explain a little bit about what's going to happen. I understand there's two unusual things that may occur here that are not typical, but we're going to try to stick to the routine script as much as possible. That typically means we start with any announcements from staff. We're going to start there, and we can go down the list with Nate and introduce everyone so everyone's adequately acclimated.
Good afternoon, Chair Moore, board members and members of the public. My name is Nathan Pennington, the Planning Director here for Buncombe County. Just a couple of opening remarks. Also wanted to make you and the board aware of the various subject matter experts that are in the room today. First being, this is not a legislative matter. This is a conditional use permit application. Please note that the Buncombe County Board of Adjustment makes decisions on development applications based on quasi-judicial procedures. These are somewhat similar to rules followed by courts of law. Because of this structure, the board is held to strict standards as it relates to their evaluation of applications. The board's decision may not be driven by arbitrary or unqualified opinions, fears, or hearsay, but is determined by factual evidence based on exhibits, testimony, and expert witnesses. The conditional use process differs from other local governments, but it is not uncommon and is widely used across the state of North Carolina and throughout the United States. While community members may participate in the hearing, it is important to note that any testimony given must be sworn, relevant, non-repetitive, and factual. Opinion evidence may only be given by qualified experts. Chair Moore will discuss the procedure for testimony in more detail, as well as how we will swear in witnesses, given the large number of people present in the room today. Mr. Chair, I present to you that the following people, as well as others, are present in the room for any questions that may arise. Myself, in my role as the Planning Director, Josh Freeman, as the Zoning Administrator for Buncombe County, Cynthia Fox-Clark, as the Floodplain Administrator for Buncombe County, Doug Sharp, as the Erosion Control Officer for the county, Carla Fernari, as the Buncombe County Greenways Coordinator, Brandon Freeman and Michael Frew as Buncombe County Attorneys. There's also representation from the City of Asheville, as well as the NCDOT. We have Ken Putnam, Andrew Seabor, and Nick Dorado. There's also attorneys representing both the opposition and the applicant's attorneys as well. John Noor, I see Eric Edgerton, as well as Lou Bissett and Bob Ost representing the applicants. And with that being said, that concludes my presentation.
Thank you very much. Can everyone still hear me all right? This microphone? Fantastic.
Chair Moore, one additional thing.
Yes, please.
There are restrooms located out here in the hallway. Just as you exit, make sure you use this door and just kind of follow around. There will be people out there to direct any folks that need to use the facilities.
Excellent. Thank you. And if everyone could try to remain as come and go as you need to try to remain as silent and helpful as possible in facilitating this. We have a lot of people in the room, and I hate to miss any vital portion of the presentations and hearing people's cell phones go off or anything. So now's your good chance to go ahead and put it on silent. If we can go ahead and introduce the board members, starting with Robbie, and we'll work our way over.
Robbie Taylor.
Tom Christ.
George Lycan.
Martin Moore.
Dot Cordell.
Andy Ball, Keith Levi, Wendell Howard.
Excellent. Okay, so to begin with, I understand we normally start with a motion to approve the minutes. Does everyone have a chance to review those from the October 9th meeting? I'll entertain a motion on that.
So moved.
Second.
A motion and a second to approve the October 9th minutes. All in favor?
Aye.
Any opposed? Those are so approved. Before we begin, any disclosures or conflicts that need to be shared at this point, I will go ahead and preemptively put out there. I received an email from the Chamber of Commerce. I did not open the attached letter. I forwarded that to council and staff. Just so everyone here is present, some of you may have received this letter. That is not admissible at this time, not that it wouldn't be down the road if someone properly admitted that into evidence. However, if you did receive that, I'm directing everyone now, do not consider that in any deliberations. I don't know the contents of it. My understanding is council may or may not have read it at this point, but it would not be admissible at this present time. Has anyone else have any conflicts or disclosures at this time? Any basis for recusal? Okay. Ladies and gentlemen, we have, and this is probably more relevant for council, one more member that is actually necessary. We have an alternate here as well. Wendell will sit in, listen to all of the evidence, although he will not be a voting member, absent some extenuating circumstance, but just so all parties involved with legal standing understand that. All right. I'll go into my sample opening statement after this. I suppose we have a motion that we need to entertain before we hear any evidence or introduce any project that was submitted by council for the homeowner association, and I understand that the city is here as well, so I'd like to entertain that first unless someone has an objection. If you don't mind.
Good morning. My name is John Noor, and I represent the Malvern Hills Neighborhood Association, as well as neighboring property owners Carol Warren, Jolene Elkins, and Jesse Courtney. This is our motion to continue the hearing from today, and we're joined by the city of Asheville in that motion that is also asking for the continuance. The basis of our request are three different reasons. One, the first is under the Buncombe County Ordinance 78-677D, it requires that the application be submitted to the board 30 days in advance of the hearing. Now, the board is aware that this was first set for hearing in October and that the applicant asked for a continuance at that time in order to make changes to that application. Those changes were made in revised applications, site plans, revised traffic assessment, as well as new maps were provided to the county, but those materials were not made available to the public or to my clients within the 30 days prior to this hearing. In fact, I don't think it was made public until either the last day of October or the first day of November. As a result, my clients had not had 30 days they would be provided under the ordinance to review those materials, share those with their experts that they have retained to provide expert testimony on this. And they are not in a position right now to proceed with this hearing. We will if the board chooses not to deny the motion to continue, but we are entitled to those 30 days. We would ask that we be given those 30 days and ask that the board continue this hearing until its December meeting so that everyone has the time they're entitled to in the board. So that's our first reason. Second is the applicant asked for an extension at the last meeting. They needed additional time in order to make their application better in their eyes. They got the fairness of a continuance in order to revise their application. We are asking for the same here, nothing more. We have experts who are here presently, but we also have two additional experts that we've been trying to retain. Unfortunately, due to their schedules, they were not able to be here today due to the timing and their inability to review the revised applications in enough time from when they were submitted and made public. The last would be, we know from the materials that were provided to the board and online that the DOT only received the traffic impact analysis in this case on October 31st. And there in the correspondence that they provided indicated that their review will not be done until December 2nd. So even though I think DOT members are here today, I may be wrong about that, they will not be able to provide any advice to this board on what they think the traffic impact will be because they have not completed their analysis. We would argue that let's let DOT do its job, let's let it review that report, come up with a response, and then they can share that with the board at its December meeting. Additionally, the city has joined us with this motion to continue the hearing for reasons related to their own review. We'd ask that the board grant this. This is a major development project. And I think it's really important that both the applicant and the developer and the community be given the fair opportunity to present their best cases for this board to have the most information it can to make the best decision possible. We ask that the hearing be continued. Thank you.
Mr. Anderson, do you wish to speak on behalf of the city?
No, we don't have anything substantive to add. I'll just note that Mr. Noor is correct and that the city is joining this motion to continue.
Thank you.
Mr. Chair, just a point of order. I think it might be best for the sake of efficiency to have the applicants establish standing before we go in. Or not the applicants, I'm sorry. The attorneys who just spoke give a showing of standing on behalf of the clients they represent.
Thank you very much. Mr. Noor, Mr. Anderson, if you'd like to speak to the standing issue.
I can speak to the standing issue for my clients, Your Honor. The first attached to our motion to continue is the affidavit of Malvern Hills Homeowners Association, Neighborhood Association, and Kate Millar. Kate Millar is the incoming president of the association and also is a resident of the Melbourne Hills Association. In that affidavit, she provides information to the board establishing that the association's member homes are within 0.2 miles of the proposed development, that they use the intersections that are being analyzed in the TIA analysis primarily for their access to I-40 and I-240 and would be impacted by the traffic coming off of this development. They also provides testimony about the use of the greenway that is abuts the development to the east that's on the city of Asheville's property, and that they use that for swimming purposes, and that their concerns with this development relate to stormwater and other health and safety issues related to that stormwater. All of those are considered special damages under North Carolina law that, if proven, would provide them with standing in this case to challenge the development. My client, Kara Warren, is the property owner immediately north to the property. It is abutting across Hominy Creek on Sand Hills Road. She shares the same flooding, stormwater, and erosion problems. These would be direct injuries to her property. And under the condition, it has standing to challenge this under the injury standard. Miss Jolene Elkins is another client of mine. She's here today, and her property is immediately abutting the property to the west across South Bear Creek Road, and her property would be impacted again by the traffic created from this development. I think all of those facts, I'm happy to, if the board would like for that testimony to be solicited, I can have my clients come up and provide that at this point. But that would be the summary of the special damages that we allege would be sustained from this development and establish a standing.
Yeah, I imagine that before the applicant speaks, that an issue of contention is going to be the city standing. Do you care to speak to that?
Happy to. The issue of the city standing is somewhat touched on by Mr. Noor already. The city has a greenway immediately across from the proposed location, so this has been a somewhat rare circumstance where the city actually is a adjoining property owner to a project that is outside of its jurisdiction. So we are a neighboring property owner like some of Mr. Noor's clients and would have standing for the very same reasons. I have not submitted any affidavits to the board at this point in time. However, there are members of city staff here who are willing and prepared to testify to the fact that the city owns real property immediately adjacent to the property. Any impacts to that property would give rise to the same standing that the neighbors have in this instance.
If I may, Mr. Chair, just one additional point. And I would add that at this point in the hearing, the allegations of standing are sufficient to establish it in order for testimony and argument to be presented. We would obviously have to prove those elements as part of our presentation, but we have alleged them at this point.
For the applicants, would anyone like to speak this time?
Thank you, Mr. Chairman. We did receive the motion to continue last evening. And the points I would make in response to that are that we don't think that the movements have standing. We think that it's first of all, there's no monetary damage alleged in the motion, and the type of special damages that are alleged are damage that will occur to be experienced by everyone in the neighborhood, if they're experienced at all. So we don't think that they have alleged special damages in the way that the law requires. And so for that reason, we don't think that the standing has been sufficiently alleged. But I'd be glad that they've not made the motion they've not argued their motion to continue yet. But since standing is a threshold issue, we would argue that they lack that. I've got one thing I'll hand out from David Lawrence's book. I'll hand this to your lawyer if you don't mind. I don't have enough copies for all on the board.
Get a microphone.
What did you
I'm
say?
having a hard
We can't
time
hear.
hearing.
We didn't
Y'all
hear
hear
what
him?
you said.
Excuse me, folks, I can ask him to speak up. I'm perfectly fine to do that. If you can just raise your hand and I'll get a gist of what you're saying, but it would probably facilitate this going a little bit quicker than a couple hours if we don't all speak. Is that fair?
And I'll stand closer to this microphone. Sorry about that. And in that, it's one thing to even being directly adjacent to a property that's being rezoned or for which conditional use permit has been requested, is not enough to establish standing. In addition to that, you've got to establish or allege some kind of special damage, and that special damage is damage that is separate and apart from other damage, from whatever is going to be experienced by the rest of the neighborhood. And in this case, we just don't think that that either the motion or the affidavit establishes that. The affidavit itself establishes that these folks are not directly adjacent to the property that's going to be the subject property here, and the kind of secondary effects they allege are traffic, congestion, light, which is not going to be experienced just by their property. So it's our position that they lack standing.
May I respond, Mr. Chairman?
If you have one moment, I know council has a copy of the case that was just handed over.
It's not a case, it's an excerpt from a book. I'd be glad to hand a copy to you, Mr. Chair. I don't have enough for everyone.
Mr. Chair, this is page 30 of the quasi-judicial handbook, if anyone has it.
Oh, thank you. Thanks, sir. I'll hear from you.
Thank you, Mr. Chairman, members of the board.
I am happy to put on my clients right now to give testimony that would establish exactly the standing that we're talking about. But as I already said, Ms. Warren is an abutting landowner across Humley Creek. The testimony that will be coming from her will be related to flooding, excess flooding that will be caused by this project, will directly injure her property, not neighboring properties, her property. We have an expert witness prepared to testify that this will decrease the value of her property. Those are special damages. That's the definition of them. That is the same with Ms. Jolene Elkins related to traffic impacts and the damage that will cause to her property. We also will be talking about that same expert will be providing testimony about the injury that will occur to the city of Asheville's Greenway project and the damage that would be caused as a result of it. These are all special damages that relate to these clients that will be speaking today. We have standing to be here. And again, as I emphasized before, the case law is clear. At this stage in the hearing, all we have to do is allege that we have standing and that we have facts to support that. We will eventually, during the hearing, have to prove to you, present evidence that shows those things to be true. But we've met the burden in alleging our standing at this point, and we happy to answer any questions you might have or present the evidence, additional evidence to support that.
Thank you. And I would like to have a question for counsel in a moment, but at this stage, let me ask the applicant, if he's alleging standing, he's stating that he has special damages and meeting the, at least from an allegation standpoint, asserting that he has standing the proper way, are you seeking testimony from those witnesses at this time, or are you saying that they couldn't offer that even if they did speak?
Mr. Chairman, members of the board, it's true that they have alleged special damages, but that's all they've done. They've not been specific until Mr. Noor just spoke about what kinds of damages they were going to, that they expected to experience. And so this is a threshold question that this board has to respond to in order for them to participate as parties. Now, that doesn't mean they can't, that the folks here can't speak, but if they're found to have standing, they get to participate as parties in this matter. And if they're not parties, well, then we would contend the motion to continue without a order, because only a party can ask for that.
I agree with that. I think that standing is the threshold issue for us, but I suppose that they're saying that they're prepared to prove that at this time, and it's really going to be giving them an opportunity to do so from a due process standpoint. Would you agree with that?
I'm sorry, could you say that again?
If they're alleging standing and they're saying that they have standing and that is a threshold issue, we both agree on that. Are you requesting that they have the opportunity to prove that at this time? Is that your preference? Because that would be my understanding is that procedure, and counsel, correct me if I'm wrong, but now would be the appropriate time to allow their witnesses to speak to whatever they want to speak to, and then the board would have to make a decision as to standing. Is that your understanding as well?
Just a moment.
In the interim, if I can just call on counsel, is that a correct interpretation as you understand it?
Yes, Mr. Chair, I think that's correct. I believe that without a stipulation between the purported parties, that the board would need to have evidence on this issue. And now would be the appropriate time to hear that evidence.
Chairman, I have one question. Would it be advisable before we dive into that to have some comment from staff on the notification issue, if there's some clarity they can provide on that?
I'm happy to let him do that. I'm not sure that we could hear a direct answer from anyone other than staff until the standing issue is resolved. So if Nathan wants to speak to that.
So in looking at the zoning ordinance, the 30-day requirement is the requirement for which plans and applications must be submitted. This is not necessarily the notification time. That's a 10-day requirement. So that's when you need to have the application to staff for review. That's
30
the
days
difference.
prior?
What's that?
30 days prior,
30 days prior to the hearing.
and then the 10 days is
The
notification.
10 days is the requirement as set out in North Carolina General Statutes. We actually have a threshold for notification that's 1,000-foot radius, and that is significantly above the minimum requirement for notification.
Do we know if the application was received 30 days prior to this meeting?
So the application was received prior to the previous meeting where it was continued. We did receive a couple of extra detailed plans that indicated in more bold lines the extent of the floodway and floodplain and things like that. There were no material or substantive changes as they relate to the number of units or the square footage of the commercial floor area of the project itself.
And just for the record and the parties watching, that is probably an appropriate consideration for the motion to continue itself once we pass the threshold issue of standing, which is what I understand we're going to address next. Did the applicant have a response or wish to be heard on that issue further before I speak to the other side? Do you have a response? Do you have any objection to them going ahead and trying to assert their standing at this time?
The answer's no.
Mr. Chairman, I think in view of the fact that, that the implications of this are that they get to participate as parties or not, I think we ought to hear the evidence of standing now.
Agreed. Mr. Noor, if you'd like to begin.
At this point, and it's possible that a couple of my, I'll put this on, a couple of my witnesses and clients may be outside, so if that occurs, if the board would humor us to give us a little time to bring them into the room, I would appreciate it. At this time, we'd ask Kate Millar to come up, provide her testimony.
Ms. Millar, when you step up, we're going to have staff swear you in, so if you can stand right in front of the microphone and answer staff's questions, and then Mr. Noor can ask you whatever he wants to ask you.
Okay. Raise your right hand. State your name.
Kate Millar.
Do you affirm to tell the truth and the whole truth, and nothing but the truth?
I do.
Okay. Good morning, Kate. Could you give your full name to the board, if you don't mind?
Kate Millar.
And where do you live, Kate?
I live at 19 Cranford Road in Malvern Hills.
And approximately how far is your personal house from the proposed development?
My residence is about half a mile.
Okay.
Development.
And are you involved with the Malvern Hills Neighborhood Association?
I am. I'm a current board member and the incoming president.
Okay. And have they authorized you to come today to testify on behalf of the association?
Yes.
And what is the purpose of the association?
The purpose of the association is to promote our neighborhood community and to provide for the public safety of our neighborhood.
And based on your involvement with the association, do you have any knowledge about what roads your association members use in order to access Interstates 240 and 40?
Yes, from our neighborhood to get to 240 or to I-40, you would be using South Bear Creek Road and Sand Hill Road.
One quick question. Would it be possible for her to indicate maybe some of the roads that are part of the association so we can get an idea of the boundaries?
Absolutely.
So Malvern Hills, usually when people say that, they're describing a larger area, but the Malvern Hills Neighborhood Association describes a smaller area within that. It's about 200 homes, and the roads are Wendover Road, Cranford Road, Bear Creek Road, School Road, So if you're looking at a map, it would be bounded by Wendover, Bear Creek, and School.
Kate, if you could face that to me so I can, for the record, you have pointed to Wendover Road, Sand Hill Road, Bear Creek,
So here.
and these are roads
Runs this way.
depicted on the Crossroads at West Asheville conditional use permit map provided as part of the materials for this meeting, correct?
Correct.
Okay.
So this is the edge of our neighborhood.
So the corner of your neighborhood, that last house that's part of the association, how far is that house from the development?
That house is about 1/10 of a mile, maybe 2/10 of a mile from the development.
Okay. And that Wendover Road, is that, was that intersection of Bear Creek and Wendover part of the traffic impact analysis that was submitted in support of the application?
I think it was added. The Wendover, Bear Creek, Sand Hill intersection was added.
So that specific intersection is part of the analysis that's being submitted in support of this application?
Yes.
Yes. And the members of your association, including you, use that intersection as part of their travel to and from 40 and 240?
Yes, we use it daily.
Okay. Can you tell me about the impacts that your association is concerned about related to this project?
Well, that intersection in particular is already a mess. We've already got a situation where it's really congested. You often wait there for a long time. You drive up to the intersection and you don't know what to do. You have no pedestrian crosswalks. You have people trying to cross from our neighborhood to go to the greenway or to go walk, and that intersection is already terrible.
As part of that intersection, tell me just give the board an example of what kind of backup do you personally see on a given evening or morning when you're heading out to work, coming home?
At that intersection, you could be waiting for, at rush hour, you could be there for 5 minutes or so. Right now, it's misaligned, and it's a four-way stop. So often it feels like you're playing chicken. People don't know when to go.
I'm going to ask you, this is speaking to substantive elements. If we're focusing solely on standing, I understand the point.
As to the traffic, I'm happy to move on, but we've provided testimony on the traffic at this point. The members of your association use the Hominy Creek Greenway that abuts the proposed development?
Often.
Okay. And how did they use that greenway?
For recreation, people go there to exercise, walk, recreate, swim, be in the green
One question
space.
for that, just as a clarification, is that a city-owned and managed greenway?
It's a city-owned greenway, and they have an agreement with the Friends of Hominy Creek Greenway group to help manage it.
Is this on the property that the city of Asheville?
It is on the city's property. When you mentioned swimming as part of that, can you tell me what is it adults, is it children? Who's using it for swimming?
You see everyone. On a nice day, you could go down there and there would be a lot of people in the water. You often see kids on the beach there at the Hominy Creek Greenway, soaked, up to their chest.
And as part of your review of this application, did you retain an expert to review the project to give you an assessment on the impact this project would have on water quality, stormwater, and flooding along the greenway?
Yes.
And was that, and I won't go into the details except for the point of proving special damages, but was that assessment that it would negatively affect the greenway water quality and create a swimming hazard in that area?
Yes.
Okay. If I can have just a second, Mr. Chair. You mentioned earlier crosswalks and sidewalks. Do members of your association use the South Bear Creek Road currently to walk down over the bridge that is there?
Yes, you can try to.
Okay. Are there any sidewalks there to facilitate that?
No, you would be on the road.
Okay. Those are the questions I have related to the association and Ms. Millar's individual standing in this case.
Do any board members have any question as to standing for this witness? Thank you.
Okay. At this point, I'd ask that Kara Warren, if she is been able to make it into the room. Hi, Carol.
If I can stop you for one moment, did the applicant have any questions for this witness?
Just a few from Ms. Millar. Can you hear me?
Yes.
Ms. Millar, you described a number of effects that are anticipated if this project is built on Caney Creek, Hominy Creek, and the roads right there in the intersection. Now, are those effects going to be experienced? And did I understand you correctly to say that that those effects would be experienced by the neighborhood?
Yes.
That includes no sidewalks, the potential for flooding. Does that affect any one particular property or the entire neighborhood?
I think it's the entire neighborhood.
Thank you. No questions. No further questions.
If I could redirect.
Please.
Ms. Millar, when you say the neighborhood, you're not talking about all of West Asheville, everybody. You're talking about your association, your small knit, the Malvern Hills Association, correct? You're not referring to the neighborhood in general, are you?
No.
Okay.
About Malvern Hills.
So you're talking about Malvern Hills. And individually, when you testified about the folks who use the Greenway for swimming, those individual folks would be impacted by water quality issues by swimming in Hominy Creek, correct?
Yes.
And that would be separate and apart from the rest of the broader neighborhood, correct?
Yes.
Okay.
What do you define as the broader neighborhood?
Me, what do I define as the broader neighborhood? I think there's something like 5,000 people or homes within a mile of this development.
Any further questions?
Nothing further.
At this point, we'd ask Ms. Warren to come on up.
Thank you, Ms. Millar.
Mr. Chair,
Yes.
if I might, just for everyone's benefit, if there are people who you're going to be calling that are not in this room, we have folks stored upstairs in the commissioner's chamber. We're in communication with them, so if we need to call someone, it may take a little time to get them here, but we can do so. So I just want to make sure everyone's aware that that may have to happen as part of the process.
And just a point of order, Mr. Chair, should these folks be sworn in?
She was.
Okay.
Ms. Millar was.
I'm sorry, I must have missed.
Just for convenience, Mr. Chair, the other individuals that I would be asking would be Jolene Elkins, and I'm not sure if Ms. Elkins, she is in the room, okay? And then I know we have one of our experts in the room already, and is Hartwell Carson in the room? That might be the other one we'd ask for standing.
Who is waiting with me right outside, and when I finish, I can go out and get him.
Okay.
Our staff will take care of that.
Thank you.
Thank you.
Good morning, Ms. Warren.
Hold on one second.
Yep.
You have her sworn in.
Yeah. Raise your right hand. State your name. Do you affirm to tell the truth and nothing but the truth?
Good morning, Ms. Warren. Could you tell the board where you live, the address?
460 Sand Hill Road. 460 Sand Hill Road.
And where is that property located in relationship to the proposed development?
Directly behind it.
Right across Hominy Creek.
Right.
So your property line touches the development's property line in the middle of the creek.
Correct.
Okay. In this situation, have you reviewed the proposed development plans that were submitted in the application?
Yes.
Okay. And as part of your review, did we hire a engineer to review the flooding, stormwater, and swimming impacts that might come from this proposed development?
Did I?
Not you, but have we looked at the impacts that the development would have on your property related to stormwater?
Have you?
Yes. Yeah. And as part of that review, did you have concerns about the impact flooding would have directly, not on everybody's property, but your particular property?
Absolutely, yes.
Yeah. And those impacts would include erosion to your to the stream bed along your property?
Yes.
And flooding to your home in particular?
Yes.
Okay. Mr. Norr, could I just ask it? I'm going to give you some leeway on leading questions. If you don't mind, ask her some questions and let her give her response.
Are there other concerns that you have in particular about this development and the impact on your property?
Yes.
What are those?
Well, erosion and water, how the water is going to move the way the property is behind my house. looking at the plans, it looks like the water is going to have a very negative impact on erosion in the water. The pollution that will be caused to Hominy Creek, which is a recreational and very special place to be, my family and our neighbors. So that's of concern. The impact of the light, the impact of noise, the impact of traffic. It does not seem like a thoughtful or sustainable plan for that particular area.
Have you seen anybody use, do you or seen anyone use the greenway that's nearby your property?
Yes, we use it weekly,
Okay.
not more.
And swimming, have you seen folks swimming in the water along the greenway there?
Yes, and we do it behind our house as well, and our neighbors do as well.
When you say we, who's we?
My children.
How many children do you have?
Two.
Okay.
2 little girls.
At this point, I don't have any other questions for Ms. Warren.
Ms. Warren, what is it Warren?
Yes.
Okay. What is you said that you were concerned about erosion and pollution. What is the basis of that concern?
The way the property is, it's not that much land. In the way the proposal looked to me, it looked like there was going to be a lot of cars, there's going to be a lot of parking, there's going to be a lot of runoff, and the land goes down, it slopes down, and then there's a floodplain, and then the water, all of that water, how it's going to move through the land is of concern. It already does that at my house. It's concerning even at my house how much runoff from the road just goes down into the creek. So imagining the difference in the impact with the number of units and how much traffic that will include is of concern.
So this is your speculation, is that right?
Correct.
And what about you also mentioned the effects of light and traffic and noise. Is that
Correct.
Same basis?
Well, yes, there's going to be light because there's going to be large buildings. It's not a normal residential home neighborhood like we have in the rest of the area around our house. It's very, very different. I was trying to look at examples within the city and couldn't find anything that was even close to that.
I have no further question.
Any additional questions?
None for Ms. Warren at this time.
Thank you, Ms. Warren.
Okay, thank you.
I'd next ask Ms. Elkins to come on up, please.
And for convenience sake, if staff can have the next person ready about 2 minutes into her discussion.
Good morning, Ms. Elkins. Can you let the board know where you live? And let's get you sworn in. Sorry, I keep cutting you short. I apologize.
That's okay. Raise your right hand. Do you affirm to tell the truth and nothing but the truth? State your name.
Jolene Elkins.
Good morning, Ms. Elkins. Can you let the board know where you live in relationship to the proposed development, or the property that you own, I should say?
The property that we own is directly across from the church. It's at 51 South Bear Creek Road.
Okay. And have you reviewed the application and the plans that have been presented in support of it?
Did not review the revisions. I did not know they were out there. There was no notice that there were revisions to them.
Okay. In reviewing that, what are the kinds of issues that you identified that you had concerns regarding your particular property concerning the development?
I'm going to say first, I am a native of Asheville, and I have a lot of concerns other than just my property, but related specifically to my property, which is, I understand, the only thing that you can consider is the traffic. It's already horrible there. I have a picture on my phone that I tried to print out of 18 cars 2 Fridays ago in line in front of the church trying to get through that small area on South Bear Creek Road. And that's not unusual. I've seen them backed up all the way to the campground. And the impact of another 1,500 to 2,000 cars on 2-lane roads, there is no 4-lane to this property, none. It's all 2-lane residential, relatively rural roads coming into this property. And putting that many cars additionally on those roads will be a nightmare.
Is the front of your property essentially across the street or within a few yards of the primary entrance proposed for this development?
Yes, sir.
Okay. Is that part of your concern in the damage that your property would receive?
Very much so.
Okay. And is it that proximity to that entrance that?
Yes.
Okay. Are there any other concerns directly related to your property that you have other than traffic?
Well,
And the
related
impact that
to
would
the
have on?
traffic, there's the DOT proposal, and we're still looking at what the DOT is doing. I don't think they've made a decision on that. That will also impact our property, but it would also impact this property.
Okay. Those are the questions I have related to this witness.
Ms. Elkins, the traffic backup that you say you experience, is it just your property that fronts on that segment of South Bear Creek Road?
I'm sorry?
You were speaking of the traffic backup from on the south. You live on South Bear Creek, correct?
I own the property on
Okay.
South Bear Creek.
And you're speaking of the traffic backing up on South Bear Creek, trying to get out onto either turn left onto Sand Hill or right onto Bear Creek.
Yes, sir.
Now, are you the only property owner on that segment of South Bear Creek?
Oh, no, there's several, and I think there were more planned to come today that will be impacted by that.
And are there some houses or some lots that are located behind you to the west?
I'm bad with directions. I don't think so, because we own 4.5 acres, so we own all the way back to Hominy Creek.
Well, just to be clear, so as you're traveling uphill on South Bear Creek Road, your property would be off to the right. Is that correct?
That's correct.
And are there any folks who live behind you?
Not between me and Hominy Creek.
Okay, thank you.
There's, going up the hill, there's one more property owner, and I believe he's also here today.
And there are there are at least one road that turns off of South Bear Creek Road and sort of winds back into a neighborhood back there. I believe it's a private road. Are you familiar with that?
Fury Drive?
Yeah.
I'm very familiar with that, but that's my property also.
And are there approximately how many homes are there back there?
2.
Okay. No further questions.
If I can briefly redirect, your particular home, though, is almost directly across from the primary entrance, though, correct? Or slightly off?
Slightly off.
Slightly off. So unlike the rest of the homes along South Bear Creek, you would be individually affected because of the intersection that is in very close proximity to your property, unlike the rest of the homes along the road.
Correct.
Okay.
And especially the entrance to the storage buildings, correct.
Okay. Thank you. I have a couple more witnesses related to expertise that would substantiate the claim or the allegations that you've heard. Again, as I've said to the board, at this point, I believe our burden is only to allege special damages, not prove them. So I don't think that that's necessary, but we are prepared to put that on if the board feels that that's required in order for them to establish our standing to file the motion to continue and it be considered. We would, but I don't want to waste the board's time with those. Before we got to those experts, though, I do have one additional affidavit from my remaining client. My remaining client is Jessie Corpening. Miss Corpening is elderly and incapacitated, and so she is not able to travel to this hearing or any other appointment without a great deal of assistance. Excuse me? Oh, sorry. I thought I heard the worst thing you could say is someone's incapacitated, not be able to hear, and then they pop up in the back of the room. So. But her son has been appointed as the power of attorney for her and has submitted an affidavit that I'd like to provide to the board that talks about the special damages that their property would sustain related to glare coming off of the property. I know that because Ms. Corpening can't be here, that obviously impacts the ability of the applicant to cross-examine Ms. Corpening, but this is sworn testimony. And this is a quasi-judicial hearing, and so the rules of evidence do not apply that would prohibit this. You may not give it the same weight you do other testimony, but I feel that it is important to provide that to the board at this time.
Given the circumstance, does the applicant object to him trying to submit that?
I'd like a copy of the affidavit.
Absolutely. We have a copy for you. Thank you. I have copies for all of the board members, but they're in binders.
Council needs some.
As over to staff. I'll let them know. We can address that in one moment. I won't deny you a chance to readdress that issue before we go further. I did have one question based on what you just said. For the applicant's attorney, based on what he shared about expert witnesses, I guess I'll kind of do something informal here and asking you, do you want him to have those experts testify? The reason I'm asking you that is because I understand that there could be some substantial prejudice that might result from that. You can't unhear certain things, but if you would like to hear the specifics of what he's alleging to be special damages, I'll try to limit that as much as possible. But if you otherwise would confer with him and discuss the nature of what they're going to say, I think that might be advantageous to both.
If I can have a moment to consult with my co-counsel and my
Please.
client.
And while the attorneys are conferring and preparing, you might want to go ahead and prepare the affidavit just in case. If counsel would like to offer a recommendation as to the admissibility of the affidavit, if we can consider that, unless you have an objection.
No, let's say, Your Honor, Mr. Board Chair. I did want to mark that just though for the record, if I could, if that copy that I handed up to the chairman
Absolutely.
was available, if I could mark that. I'll just start with Exhibit 1.
Sir, if you could mark here. We'll note that affidavit as Exhibit 1 without making a determination on its admissibility until the board's had a chance to see it. Sure. Are you having
Are we
with the
allowed
hearing?
to ask any questions at all during this? Because I have only one.
Are you an attorney?
Not,
I'm sorry?
no, I am not.
Okay. I think as to this issue, unless you're a party that's asserting standing and or specifically looking to intervene in this specific portion, I'm not really sure what the circumstance would be that
I was just curious
would
how
allow us to
we
hear
gotta
anything from
continue
anyone.
and see, but we can't.
We're not, ma'am, we're not addressing that issue right now, so I hear you. We're not even addressing the continuance at this stage. We're addressing standing about whether or not we can even hear that motion at this time. That's the threshold issue right now before the board. And once we determine that, then we'll have argument as to the motion itself.
Oh, did the same thing happen with them?
Just so everyone understands procedurally, at the last hearing, the previous party, who's represented by an attorney, requested a motion to continue. My understanding is that the first threshold issue we have to address here is standing, and there's an attorney representing a homeowners association and several individuals who is allowed to request a continuance, but we have to address the standing issue first. Applicants are presumptively deemed to have standing if they have a lawyer representing their interest and they're an applicant.
Give us just 1 minute, please, Chairman.
So it's kind of shady.
Mr. Chairman, at this point, I don't think we need to hear from their experts.
You said you do?
We do not.
Okay. Do you have any issue or objection after reviewing his affidavit to stipulating to that? Its admissibility or?
Frankly, I haven't had a chance to look at this while we're talking, but the first thing I would note is that this is on Shelburne Road, which is on the other side of the creek and kind of behind the project. Mr. Chairman, there are some allegations in here that I don't see the factual, any kind of a foundation for. Things like the exterior and parking lighting, and I'm reading through this affidavit that appears to be the secondary effect that Ms. Corpening is concerned about, but I don't see any foundation in the affidavit for to back that up.
To back up the substance of the statements?
Yes.
Okay. I think that my understanding would be that would be going to the weight of it, not necessarily the admissibility element. Is that?
Well, I point that out for just to bring that to the board's
And I will give both parties an opportunity to make closing statements and to point out each element of each witness and the testimony provided. If you have no objection to its admissibility, I'd like to look at it before we make a determination. I have not seen it myself, but as you hand that out, did you want to call your next witness? We can consider everything holistically. Given he's kind of stipulated, doesn't need to hear on the next experts. Do you have any more witnesses that you'd like to call?
I do not have any other individual clients that I would like to solicit testimony from related to standing. Those are the 4 clients that I represent. I did want to respond briefly to the question about the affidavit, and that the response is the statements about lighting get to exactly why my client is concerned. So one of the explicit conditions for the conditional use permit is impacts of glare on neighboring and surrounding properties. My client's concern related to the topography of the proposed development and the lighting that would be needed for the parking and the units themselves is that lighting is going to shine, considering the close proximity, right across Hominy Creek into that home where his mother resides and where my client lives. And so that is the foundation for the special damages. That would be her property, unlike any other property in the surrounding neighborhood. That affidavit is based on the information provided in the application and the site plans related to topography and elevation of the buildings and height of the buildings. And I think it's directly related to those damages. That's the evidence I'd like to present for standing. I'm happy to answer any questions the board may have. And I think the city wants to put on at least some evidence related to its standing in this situation as well.
Do you have any further comments on the affidavit?
I think that any observations I would have would go to the weight of it and not the substance of it. Again, Ms. Corpening's not here. These concerns about lighting appear to me to be speculative, and so I would just note that for the board's consideration.
Thank you. And I'm going to let that circulate. We'll take that under advisement for now and then make a determination upon hearing from the city and then closing arguments and make sure that we come back to that issue. And if I don't recall, if I don't remember, just go ahead and stop me before we close any consideration. Mr. Edgerton, if you want to speak on behalf of the city's interest standing in this case.
Yes, we'd call one witness, Nancy Watford.
Ms. Watford, if you don't mind being sworn in prior to speaking.
Raise your right hand. State your name. Nancy Watford. Do you affirm to tell the truth and nothing but the truth? Yes.
Good afternoon, Ms. Watford. Where are you currently employed?
City of Asheville.
And what is your role with the city?
I work in the Development Services Department as the stormwater supervisor
overseeing stormwater erosion sediment control and floodplain management.
And with respect to this project, does the city have any real property interests in the immediate vicinity of the project?
Yes, we own property across Hominy Creek project.
And what is the name of that property?
Hominy Creek Greenway.
Okay, and that the Hominy Creek Greenway, does that abut Hominy Creek?
Yes.
And so it is directly adjacent to the project location?
Yes.
And have you been asked to review the plans that have been submitted by the applicant in this matter?
Yes.
And based on those plans, are you prepared today to offer an opinion as to the likely flooding impacts on the city's real property immediately adjacent to the project?
Yes.
And will that opinion be that there will be substantial physical harm to the city's real property as a result of this project going forward?
Most likely, yes.
Are you going to be prepared today to testify to a degree of professional certainty that there will be likely adverse flooding impacts on the city's real property if this project goes forward?
But yes. Microphone. Yes.
We have nothing further on standing. Obviously, we'll be going into these assertions in much more detail. However, as Mr. Knorr has already recited, the allegations have been made, and the city is prepared to substantiate the fact that there will be a direct physical intrusion and harm to its real property located immediately adjacent to the project site. This, of course, satisfies the burden of showing standing, as we will incur special damages as a result of the project moving forward.
Can I give him a chance to ask Cross before you?
Absolutely.
Just a few questions, Ms. Watford, and I understand you're nervous. Does the Hominy Creek Greenway flood now?
Yes, it is in the 100-year floodplain.
Okay, but during the course of your time with the city, have you witnessed it flooding?
No.
So, what is the basis of your projected opinion that the property is going to flood?
Based on floodplain dynamics and
What?
that building in a floodplain will then cause adverse effects within that same area of floodplain.
If the building in question complied with applicable floodplain development regulations, would that still be your opinion?
Yes.
That it will flood?
Yes.
It's wetlands.
And you do understand that the project that's under consideration or at this hearing is going to have to comply with applicable floodplain regulations, right?
I object.
To the extent that she is sharing what her testimony would be if she were to testify today, I think that would be sufficient for the stage of standing right now.
I don't have any further questions at this point.
Any additional questions from you, Mr. Edgerton?
No, Mr. Chair.
Thank you. Was that Ms. Watford? Can you spell that for me?
Watford.
Thank you. Are there any additional witnesses on standing from the city?
No, Mr. Chair.
I'd like to give everyone involved the chance to make a kind of a closing wrap-up statement to the extent that you want to. Or do you both sides prepared to do that at this time, or?
Yeah, and this is on the
Solely on the
standing issue. Yes.
Yes. I'll go ahead and give Mr. Knorr first crack, and then Mr. Edgerton, and work our way over to the applicant.
Mr. Chair, Board, as we presented through the testimony of my clients, the Malvern Hills Neighborhood Association.
Try to.
You can
Malvern-
stay seated. I don't think we object. If that helps you get to the microphone. You don't have to.
Habit in court, sorry.
Only quasi.
You're lucky. So, the testimony from my clients, the Malvern Hills Neighborhood Association, Ms. Millar personally, Ms. Warren, Ms. Elkins, and the affidavits all establish unique special damages related to each of those properties. For the association, it's related to traffic, use of the greenway, safety issues related to the use of the Hominy Creek after the proposed development, stormwater, and flooding. For Ms. Warren in particular, her home immediately abuts the proposed property, is along Hominy Creek, and she has talked about her worries concerning flooding, increased velocity of that flooding, erosion along her property, and the water quality of the creek. Those are special damages. Ms. Elkins has testified about her concerns regarding traffic that would impact her property, particularly because of its proximity to the primary entranceway for the development that is separate and distinct from the other properties along South Bear Creek. And the affidavit that was provided to you talks about the impact of glare and lighting on the particular property that is across Hominy Creek to the east. That is the Corpening property. The law requires that in order to have standing, you meet a certain number of criteria. One of them is being able to show special damages. All of my clients have testified and provided allegations that they would suffer special damages. I would also note under 168-393 D3, one of the specific areas for standing in appealing these decisions and being involved is an unincorporated or unincorporated association to which owners or lessees of property in a designated area belong by virtue of their owning or leasing property in that area. That is by definition the Malvern Hills Neighborhood Association. So I think we've demonstrated the allegations of standing to substantiate why we are entitled to make the motion continue and would ask that the board consider that motion.
Not to rehash directly what Mr. Nord just said, but the testimony both from his clients and from the witness presented by the city is that the city is the owner of real property immediately adjacent to the project, that it will be, that we will offer evidence that it is likely to increase flooding impacts to the city-owned real property immediately adjacent to the project. Those get us right up to special damages. The city has a direct interest in this project and therefore has standing to present further evidence to substantiate its projected evidence of flooding impacts to its real property immediately adjacent to the project.
Thank you. Can you hear the applicant's attorney?
Thank you, Mr. Chairman, and members of the board. The concerns that I heard expressed by all of the witnesses are concerns that don't affect just their properties. So, granted, they may be shared by the compact neighborhood. They may be shared by the region as a whole, but they're not limited to just those properties. And that is the question this board has to consider: is whether these folks who are alleging special damages are going to experience those damages on their property and their property alone. If these effects are going to be experienced by the broader community, then those are not the kinds of effects that are sufficient to confer, not the kind of special damages sufficient to confer standing in this case. The other point I need to make is that these concerns are based on speculation. I heard very little foundation for any of them, and so for that reason we submit that even the city that neither the city nor the property owners represented by Mr. Noor have standing.
Mr. Chair, if we need to revisit the invitation that was made to Mr. Ost, which was for us to present our subject matter experts on those points,
I'm aware of the issue.
Happy to substantiate.
Let him finish his statement.
That concludes my statement.
Okay. As a preliminary issue, I would share that concern only because we offered the opportunity not to have the experts testify to special damages because I believe that could have an adverse effect on your application from witnesses that we really couldn't kind of rein in their testimony with respect to standing should they testify about the adverse effects themselves. But they do have them and they'll proffer them. I think that's their assertion. And I'm happy to do that, but I think that specific issue is kind of preempted by our discussion and decision not to hear directly from them. Is that fair?
That's a fair statement, but I would, if it turn, and we don't want to belabor this proceeding by bringing up a parade of experts who will give their testimony, but I would not want for the issue of standing to be conclusively presumed if it later appears that the, for lack of a better term, that the opponents do not have standing.
So I guess my struggle is going to be the only way I can see that issue not resolving itself, given the hedging on both sides, is just have you put a witness up who's an expert and testify. That's the only out that I see there. It's kind of like reserving a right to appeal something that we're stipulating to not admitting.
And if they were to bring up their experts, we'd request the opportunity to bring up ours to rebut theirs. Yes, sir.
If we're only addressing the standing issue, I don't. That's kind of the quandary that we're in right now, because their expert is only there to speak to the part that you're objecting to, which is the special damages. If the special damages are going to be proven by their expert, then having rebuttal testimony on that doesn't really go to the standing issue at all. That goes to substance that we'll address down the road, which I'm fine with. But I guess I can direct the board and say no one is to consider any evidence presented from the following witness on to any issue other than whether or not there's special damages with respect to the elements of standing. And that would be my instruction to the board.
If I may, Mr. Chair, I think this all goes to what's the standard, and this is an allegation of special damages. That's what has to be made. The allegations have been made. Now, the applicant doesn't agree with those allegations. He says that they're speculative. He does not believe what we are saying. But that gets to the hearing and not to whether we're the right people to be standing up and saying, hey, I'd like to be heard. So I think we've met the standard for standing to prove that my clients have the ability, that they are the right folks to come into the room and move to continue, that we should proceed to the motion to continue and then have the board rule on that, and then we'll proceed after that. That would be my recommendation.
What I'd like to do is ask staff at this point, and specifically counsel, if you can read the relevant portion for standing. Is the word really hinging on allege, or is it demonstrate?
Mr. Chair, if we could just have a brief moment to confer, and it would be helpful for us if counsel would provide a cite to the language for an allegation of special damages as a standard. If not, we have research capabilities, and I know you're sitting over there with a notepad, so I'm not trying to put you on the spot.
I'll work my magic if I can.
And I'm not trying to parse that out for you, but I think both sides are arguing a legal issue, and I think I'd like to take a 5-minute recess to look into that, if that's acceptable to both parties, and we can come back and have an actual definition and conclusively decide this issue so everyone can make a decision one way or the other. Is that fair?
Thank you.
Both parties agreeable? 5-minute recess.
This is Mangum, or well, so Jackson must allege truck or just fine. I'm looking at Mango, and this is what I've got in saying that it's alleged special damage. Now we got to prove them. So alleged is where we are now. That's kind of at the end of the day. So like at the end of the hearing, I've got to prove it. If I've not proven it, alleging it isn't enough. To like get through the door to make my argument, all I have to do is allege it. Like I can't prove it before I get in the door. Yeah.
Yeah, me too. I'm too water.
I can ask everyone to take a seat. Both sides have all parties present they need ready. Now that we're back. Okay. Sir. All right, just to remind everyone, we have, I just found out the number, about 100 people upstairs watching via the internet. So if everyone can speak loudly and clearly into the microphone so everyone can hear, we'll go ahead and start resolving. We're not going for the record for longest meeting, but I think we might get there incidentally. Can we have counsel go ahead and briefly offer the legal opinion solely on the one issue, kind of the wording of what we're looking for, and then we can proceed from there.
Yes, sir. In terms of standing, I think Mr. Nord briefly cited General Statute 168-393. It has elements of following criteria. Now, the elements set forth in that statute are really for a judicial appeal. It would be an appeal from this board to a superior court. So we have a slightly different statute at this point because you need to get your foot in the door. You need to have a decision made. So I found a case here, SARTA versus City of Durham Board of Adjustment. And this has to do with a zoning decision. In that case, and this is again on appeal, the petitioner lacked standing to appeal to a superior court from a Board of Adjustment decision to grant a special use permit where the allegation was that they live about 400 yards from the proposed development. In that case, because that petitioner did not allege that they would suffer special damages distinct from the rest of the community. So that is what the petitioner, the opponents have been doing, and it's up to the board to determine whether or not they have supplied sufficient evidence to meet that burden.
Thank you. All right. To our own potential detriment, I will hear from both sides briefly, please, solely on this last issue. If you can wrap up your arguments into a very quick assessment on standing, give us a quick summary, if you'd like to, in response to Council's decision, and then I'm going to instruct the board as to a decision to be made so we can all have some resolution on this issue.
I think Mr. Frew said it well when he said the key is a ledge here. This is what gets us through the door. Once we get through the door, we then have to prove these things. So we have alleged special damages. We have alleged them in the form of traffic impacts and impact on surrounding properties. We have alleged them in flooding, erosion, and water quality for properties that are immediately adjacent to the developed property along Hominy Creek. We've shown that through the affidavit related to glare directly to Ms. Corpening's house and traffic related to Ms. Elkins. I feel we have met the burden to allege the special damages required for standing.
Mr. Chair, the city's position is more narrow than that. However, there's some overlap. We have alleged that we have property immediately adjacent to the proposed site, but there will be flooding impacts on our real property as a result of the project going forward, and therefore will suffer injury to that real property. I'll further point out that the nature of the city's property, a greenway, is unique and distinct from the other types of harm suffered to other members of the community. That's the sole greenway in this area, and it's the sole one that will suffer harm as a result of this project going forward. I think we've sufficiently stated the issue for damages, and if there's any further need of reviewing case law, I'd further direct you all to the case of Bailey and Associates v. Wilmington Board of Adjustment, talking about how the allegation of proximity coupled with harm is what gets you to standing. I think that's pretty clear here.
Do you have a copy of that case with you?
No.
Applicant.
Thank you, Mr. Chairman. I agree that the threshold here is whether these special damages have been sufficiently alleged. But I think you need to look at what's been alleged, and what I heard, what's been alleged is are effects that will be experienced not just by single properties, but by properties throughout the area, if they even occur. And there's no proof that will happen. So it's our position that they have not, although they've alleged special damages, the special damages they've alleged really don't qualify as special damages because they'll be experienced not just by one property, but by all properties in the neighborhood. And as for the allegation regarding flooding of the city's property, the creek traverses many properties, and the city's not the only property owner along that creek.
Thank you. Okay. At this time, I'm going to go ahead and hear from the other staff members, other board members. Solely on the standing issue, that's going to be what we end up voting on. For whatever it's worth, I will say most of this has been and hinges on two main things for me: whether or not the standard is to allege special damages and whether or not there are special damages issue that the applicant just raised. By what I have in front of me, and I'll share that with everyone, that was provided and that we all already have in the quasi-judicial book, has a section on special damages, and that was provided by the applicant. I think at this stage, we're at a threshold point of determining whether or not it's been alleged. I think it has. I believe in the closing that was just heard from the applicant, that the alleged issue is kind of resolved. They've said it, that your issue is over the word special damages now. And that book indicates, along with case law that some of us read and seen before, that special damages is a question of fact. I think if we're at an allegation stage, my leaning is to find that there are special damages, short of them putting forth an expert and proving it right now. We have a proximity concern. We have a lot of considerations there. I don't mean to control where the board goes. Everyone should please feel free to express their own opinion. I don't know how high a hurdle we would make people jump at this stage in alleging and then saying much more than they have in terms of three. Even if we ignore the affidavit, the three witnesses have each alleged some form of special damage. The weight to be put on that during the hearing is certainly fair game as we hear it substantively once we get to the hearing phase, but I'm not sure that we're in a spot where we're considering anything other than one, the allegation, and two, whether or not we believe there's special damages. So that's what I would encourage everyone to think about.
Attorney Freeman handbook that we've all been given. I read it and studied it, and I believe it is supportive of that side having standing. I don't have anything to say about anything else, but that little book, that handbook, supports standing in several ways.
The document that's being passed around is an excerpt from that handbook. And I will tell everyone this is a conclusion each board member has to make for themselves, so don't let anyone's opinion sway your own, but as to those factors, it's something to think about.
Mr. Chairman, I would tend to agree with the statements that you made. I think it's been demonstrated that standing has been shown.
For my part, I believe that standing has been proven. We have a book that tells us of what our responsibilities are and what rules are, and I believe these people have met that standing.
I agree. I think they've met standing. As far as special damages not existing because they've affected the whole neighborhood, they're not special anymore, I have a problem with that. I think they probably do have it. Whether or not they're legitimate, we'll find out that later.
Robbie, do you have any thoughts?
No, I think that if for no other reason, but because we have one adjoining property member that butts right up to it, and then the city's property also butts right up to it, I think that's probably where the standing comes in, according to what the parameters that we've been given with our book.
So at this stage, I think it might be most helpful to vote on the issue of standing for each attorney's clients and parties respectively, separately. So I'd entertain a motion at this time as to the city or Mr. Knorr's client.
Mr. Chairman, I make a motion to find standing for the city of Asheville.
Second.
I have a motion and a second. All in favor of finding?
Aye.
Aye.
Any opposed? All right. Is there any memorialization we have to do of that on the record for staff as to the finding decision? I think we're all in agreement, but just that initial determination should be enough.
Mr. Chair, I would like to make a motion that the Malvern Hills Neighborhood Association is found to be in standing.
Second.
I have a motion requesting a finding of standing for the Malvern Hills Homeowners Association that is represented by Mr. Knorr. All in favor?
Aye.
Any opposed? Mr. Freeman, you look like you might have some input.
No, Mr. Chair, I just naturally look this way.
It doesn't matter if you're a lawyer, you still get nervous when your lawyer's looking at you. Okay. Mr. Knorr, as a formality, I know you asserted that you represent a few parties there. You have one at least. Are are you looking for something more specific? Do we need to do each one of them in turn?
I can give you those other three names so you have them. So the first was Kara Warren, who testified.
I thought it was Kate Millar.
Kate Millar was with the
She's the homeowners
Malvern
association. Okay.
Hills Homeowners Association.
Warren and Elkins.
And I will add Kate individually as well, aside from the homeowners association. So Kate Millar, Kara Warren, Jolene Elkins, and Jesse Corpening was the affidavit that was submitted. Those were the names.
I suppose we should make a determination as to the affidavit, just for formality's sake. Is there any guidance from counsel on whether or not that's even permissible at this stage?
I think the decision here might be to whether to admit it into evidence for whatever weight it may have.
Does anyone have any objection to admitting that into evidence with our own determination to be at a later time as to the weight to be given to it?
No objection.
In my discretion, then also admit that's Attorney's Exhibit 1.
Affidavit of Mr.
Jesse.
Corpening on behalf of Ms. Corpening.
Okay, so if I could have a motion as to standing for Ms. Warren.
So moved. Second.
I have a motion and a second. All in favor of finding standing for Ms. Warren?
Aye.
Any opposed? Okay. And Elkins?
So moved. Second.
Motion and second on Elkins. All in favor?
Aye.
Any opposed? Okay, those two parties have standing. If someone particularly feels strongly on finding standing for a party who's not present, I'll hear that. I would say grate a pause on that any more than the affidavit just being admitted in evidence.
I mean, my personal sense is that there's enough other individuals to provide this information, and we've always been somewhat hesitant when people aren't here to testify. So if there's not a great objection from the attorney, since we have lots of other people to speak to this.
I would only note that it's only due to her disability that she is not able to be present. But I understand the board's resolution on this. And then I would remind that Kate Millar individually and aside would also be a party as a homeowner.
Okay, to the extent we should clarify that is correct, that Ms. Millar, in her personal capacity, can I get him? Bear with me for a minute. For standing purposes, could I have a motion as to Ms. Millar?
So moved. Second.
I have a motion and second, finding standing for Ms. Millar in her individual capacity. All in favor?
Aye.
Any opposed? Yeah. Thank you. All right. Is that sufficient for?
And just for the record,
both parties?
it is no on Ms. Corpening. Is that, or no motion has been made?
No
for
motion
that?
has been made.
Okay.
And that leaves us with the city of Asheville. That was already done? Okay, good, good. I'm glad we got that in there. All right, would you like to be heard as to the motion, or do you have any other preliminary matters that we need to address prior to hearing the thing that we're here for today?
Mr. Chair, I have 1 minute to talk with the council.
Absolutely. If the lawyers are going to talk, I will say a hard 5 minutes. We are going to start whether people are here or not. This is an actual 5 minutes this time. I know the last one was a little bit of a stretch, but let's give the lawyers 5 minutes to talk, and then we can get into the substance and make a determination so all the folks here can decide whether or not they should stick around and see a motion to continue.
Could you clarify the next things that you're going to do?
The motion to continue is the only issue that we're going to be addressing to start with. All right, everyone, as promised, we're going to reconvene. And just so everyone knows, at this time now that we've established standing, this is to determine whether or not the parties who are in front of us as the attorneys even have a right to make a motion to continue. We've passed that threshold issue, so at this time we'll be hearing arguments on whether or not the case should be continued at this time. If we have the moving party start, you can stand, sit.
I keep trying to stand up.
Whatever
Just
works.
sit down. I'll keep it parked. I don't want to rehash what I already said at the beginning. I know the board wants me to be concise. This is our motion to continue, and it's pretty straightforward. First, as we cited, the ordinance, and as Mr. Pennington pointed out, requires 30 days before that the application be submitted before the hearing. 10 days notice to the community. 10 days. In this situation, the application was submitted. The applicant came in and asked for a continuance. They needed to make some changes. After they got that continuance from this board, they submitted revised. On the board's website, it indicates that the application is revised, the site plan is revised, the traffic assessment is revised, and there's additional documentation from DOT. That was provided at the end of October, beginning of November, I think, may have got up around that time. But 10 days. You've already decided that my clients are the right people to come through the door. We're asking for enough time to be able to present all the evidence we need to show our case. Now, we have experts present that can testify to a lot of the things that we talked about earlier. But in 10 days, think about your own professional careers. How many of you would be able, on a phone call in 10 days, be able to commit, review an analysis, a TIA, a site plan, an application, and be able to offer expert testimony, which is what we have to present in this case, within that period of time? Hardly anyone can. We have been trying to secure an architect to work with us on glare issues. We have been trying to secure a traffic engineer. We have had to go outside the city of Asheville to try and find an expert to do that because the firms within the town have conflicted out. We need additional time to shore up those issues. Are we going to be ready to go today? If you say yes, but not with all of the information that we need in order to fully present our case. It's a fairness issue. This developer has had months to prepare the application they put in front of this board. We're just asking for, I think at this point, less than another 30 days. Your next meeting is December 11th. With that is something was mentioned by Mr. Pennington about kind of the scope of the revisions. Well, in those revisions in the TIA and on the site plan, they scrapped all of the short-term rentals. They changed the square footage on the storage space. They changed the retail storage. All of that goes to impacts on traffic. All of that goes to impacts on the location of buildings, which would go to an environmental assessment related to flooding, stormwater, and other issues like that. So this was not, I think maybe in the scope of things, it felt like it was a minor change, but these are changes that change how we have to present the evidence in response to this application, and we need additional time to do that. Lastly, and I know that the board did not move one way or the other related to miscorporating. I mentioned this for 10 days notice. When you are someone with a disability, you don't have, and you may not live at the property that you own, getting 10 days notice isn't a lot of time for you to be able to put together all the things you need in order to show up to one of these hearings and adequately represent your own interests. And Ms. Corpening was not able to do that on such a short period of time, and it has to rely on her children who live in locations to represent her interests. Now, I think what that again goes to is fairness. This is a huge project. It is, if not the largest, one of the largest that would be in the Asheville area that's come before this board or any board in the community in recent history. We are asking that everyone be provided with the amount of time they need to be heard so this board has the best information in front of it in making a decision. That includes the DOT analysis that is not complete. DOT only received that application on the 1st. They will not be complete until the earliest being the 2nd, according to their own correspondence in your packets. Let's hear from DOT. Let's hear from the experts. Then let's make a decision. Thank you.
I have two questions kind of in the interim before I get to them, and I'm going to ask them just as serious questions about this. One's for you, one's for staff. You've mentioned the 10 days notice a great deal, and I do understand the impact of that. You and I would both agree that's very little time in a legal context, quasi-judicial context. I hear you. What about the change in the application specifically, so I can understand what you're saying, substantially prejudices you? Because that's one of the things we're considering here is how much you'll be prejudiced by this. The removal of short-term rentals, some of the other things that you mentioned there. What prejudices you that, because you knew it was continued more than 10 days ahead of time, right? You knew this was continued from our last setting because you were present for that.
I was not present at our last setting, Mr. Chair.
The parties you represent.
Some of them were. I know some of them were not.
Okay. So what's the difference in prejudice? So if we do continue it, let's play that out. We put it on to our December meeting. What will you come before the board with that you otherwise wouldn't have today?
Two of the pieces of information that we plan on having that we could not have today was an analysis related to lighting glare that we were retaining an expert to give us an opinion on, and that would impact those residents along the across Hominy Creek along the Shelburne Road area. And that's a topography issue with how the buildings are placed in relationship to how that lighting will transfer across the creek onto those properties. That's the first. The second is the traffic. When you take, and I think it was, forgive me, it might be 47 units. 42 vacation rental units or apartment units are taken off of the plans, as well as a reduction in the size of the self-storage space, as well as the office space. That changes all of the calculations related to the traffic assessment. Now you have different amounts of folks that are coming in and out in the morning for different uses. Now that the applicant had the opportunity to have its engineer make those updates and submit a revised plan. We're saying we need that opportunity to look at this revised plan that we've only had for a short period of time to make our response to that. And so I think those are the two big areas. I would also note that those are the two big areas. I think there are other areas that evolve just when you have more than 10 days to look at something. I mean, it's just an incredibly short period of time. I'll also say that in addressing the 10-day period, in some cases where there's not a lot of opposition, 10 days may be all you need. You come in, the developer has their project, no one's there to oppose it, everybody got their notice, you make your decision. I think in cases like this where there is so much community interest, giving the amount of time necessary to make the right decision promotes fairness, and it also instills trust in the community and the decision that's reached, no matter what decision that is. Everyone feels as though they were heard.
Thank you. And just for clarity from staff, Nate, I think you spoke briefly to this. Could you give us the timeline on what was given to whom at what time? I was a little unclear from that. You said maybe received. I just want to have a definitive answer. I think that is pivotal.
Sure, and I'm going to work in tandem with Josh Freeman, the zoning administrator. I will say, for the glare matter, the county does have an outdoor lighting ordinance, and that will be evaluated. It should also be noted that our application process, similar to other jurisdictions, allows for essentially a plan that's not fully to standards that would require outdoor permitting, but it does give you enough to see where footprints are located, circulation patterns, and things of that nature, with the understanding that if any project's approved, it'll have to undergo a rigorous permitting process. Be that full building plans that have to be reviewed by the various departments and things of that nature. So that's one important distinction. And there were reductions that you did hear from the applicant that they would remove the short-term rentals. And I will let Josh speak to an actual reduction if there were in any commercial floor area components.
Do you want me to speak to, apologize. Do you want me to speak to the notification first or any changes in the plans first?
Either.
Okay. Specifically regarding notifications, staff received an amended application on 10/31/2019. That's the date of the transmittal. Legal ads were sent forward for publication in the Asheville Citizens Times. Actually sent forward on 10/30, anticipating an application. Physical posting occurred on 11/1, Notice to the Buncombe County website occurred on 10/30. We actually received the application by email, so we were able to update everything pretty quickly. But the official date of public notification, I would say in terms of when things began being posted on the website, going into the mail, being posted on the property, was 10/30 and 11/1. So that's roughly 30. Brandon, anything I need to add to that? Okay. All right. In terms of changes to plans, if you'll stand by, I'm having to navigate between different documents here. The original application included 68 acres, 40 acres of disturbed area, 802 residential units, 14,400 square feet of retail space, 50,400 square feet of office space, and 64,000 square feet of self-storage. Wow.
All right, I just want to address something very briefly, because in fairness to everybody involved and offering legitimacy to whatever decision we do reach, holding up signs is on either side is going to put us in a position where we're considering things that should not be in the record. So I'm just going to request that. I don't think that either side would disagree with that statement and actually finds that it prejudices both parties' applications and their positions. So please refrain from doing that as best you can. I understand people have a lot of feelings about it. We'd like to make the best, most objective decision we can without improper conclusions that could otherwise reverse the decision we make.
All right, let me start over again there. I want to make sure I'm giving you the clear information. So, and the applicant, you may have to give me a moment here to make sure I'm getting this correct as well. So again, the original application, as I have it, based on the site plan that was submitted, is 802 multifamily residential units, 14,000 square feet of retail space, 50,000 square feet of office space, and 64,000 square feet of self-storage space. And that's, stand by. If you look at the traffic study, there's some slightly more detailed numbers there. And I'll just read this verbatim. This kind of gets into where we're talking about vacation rentals and whatnot. The Crossroads at West Asheville development consists of 384 mid-rise apartment units, 50 low-rise apartment units, 56 vacation rental units, 150 senior housing units, 64 single-family units, 11,000 square feet of retail space, and 40,000 square feet of office space. The revised application, if you'll stand by.
As you pull that up, I'm just going to go ahead and let the applicant speak. And
Okay,
I can get that.
sure, that's fine.
Thank you.
Chair, I don't know if the city who joined us in that motion wanted to make any comment.
We don't have anything to add. We've came into this late in the game, but we've joined the neighborhood group's motion to continue.
Thank you.
Ready for us, Mr. Chairman?
Yes, sir.
Thank you very much, members of the Board of Adjustment. I think Mr. Noor echoes my sentiments when he said that this is a matter of fairness. Our client came to Asheville about a year ago. They started working on this application. They've met with well over 50 different groups, met continuously with the DOT, with the county. They submitted their application on, I believe it was September 9th, which was timely. The county accepted it. The first hearing was set for October 11th, I believe, right in there. And at that time, during that time, my clients were going out of their way to take public input from neighbors, from the DOT, from the city. Well,
I'm going to ask people respectfully on both sides. I want to hear the arguments.
Well, we had a public meeting, and I'm not going to respond to them, but we had a public meeting. We had we had conversations with the Malvern Hills Association. So all I'm saying is, when we got to that October meeting, we had some things that we wanted to change that would lessen the impacts of this project. And really, as far as I can determine, and I'll wait for Josh to come up with it, but there were two basic things we did. A new site plan was submitted, and all it did was change the coloring of the floodplains to delineate the floodplains better than the first site plan. And if I need Chris Day to come up and speak to that, I will. That was the only change in that. The other thing, the main change in the traffic study was that our clients agreed to put in signalization at the famous intersection down there. Signalize that intersection, also put pedestrian crosswalks, and all of that was done in consultation with the city's traffic engineer and the Department of Transportation. So I'm trying, I thought your question was a good one. So if you were looking at this application back on September 9th, when it was first submitted and accepted, and it had these things, it didn't have any signalization. It had, when it was the changes that were made, number one, I wouldn't say minor because the signalization project is a significant cost to my client, but they're willing to do it. That was a change which I don't think anybody in this room would say that signalization causes more of a problem than before. I think it clearly lessens the impact of the project. The reduction of the rental units, or the removal of the rental units, I think that took place in the draft conditions, but my client has agreed to do that. So I know that they're saying, well, they need their experts here to determine all this, but really that could have started back on September 9th. And the two changes that were made, the two basic changes that were made, can do nothing but lessen the impacts on the community. And if we could ever get to this hearing on the merits of this, we would show you exactly how much that signalization could help the traffic flow over and above our project. But our position is, they had notice. We did everything according to the county statutes, and my clients have been here for a year. They're paying all these people sitting back here on this row. We've got 1,000 neighbors here who want to hear this matter. We're all here. Let's do it today. Thank you, Mr. Chairman.
Thank you. I'll hear from Mr. Freeman.
Yes, sir. I apologize. Let me just try this one more time. My mic will work. Okay, so the original application, and this is coming directly from the traffic impact analysis, which I think gives the most clear breakdown of the original application as compared to the current application. The Crossroads at West Asheville development consists of 384 mid-rise apartment units, 50 low-rise apartment units, 56 vacation rental units, 150 senior housing units, 64 family units, 11,000 square feet of retail space, and 40,000 square feet of office space. And that is, again, a more detailed breakdown that was the foundation for the traffic study under the original application. The revised, as it currently stands right now, and again, coming from the revised traffic impact analysis, the final proposed land use and densities have changed and are now as follows: 655 mid-rise apartment units, 147 senior housing units, 64,000 square feet of self-storage space, 14,400 square feet of retail space, 50,400 square feet of office space.
I have a question. Josh, could you look at both of those statistics, whatever that word is, and tell us what was increased and decreased and by how much?
Yes.
I actually can. I have it written down.
Relate it to the next thing.
So it went from 56 vacation rentals to 0 vacation rentals. It went from 434 apartments to 655. went from 150 senior living units to 147, went from 11,000 square feet retail to 14,400 retail, went from 40,000 office to 50,400, and it went from 64 single-family residential units to 0 single-family residential.
So it was considerable change. Okay, thank you.
Any more from either party before the board?
Well, I mean, I'm not sure we agree with Mr. Levy's calculations there. I just want to be sure that our engineer could address that. Could he address that?
Tentatively, give me 1 second. You look like you were going to say something. Is that an objection or?
If I might, Mr. Chair, it was just a response, but also I think Mr. Levy was reading out of the traffic impact analysis.
I'm reading off the conclusions, suggestions of the revised traffic impact analysis and the executive summary off of the original traffic impact.
So I think that's from the applicant themselves on that change. But if now's the right time to respond to the argument that was made, I'll do that, or I can wait for your.
I have no objection to him allowing his witness to say the difference, and then I'll certainly give you a chance to rebut, share everything you do.
Thank you, Mr. Chairman.
Yes, Chris Day with Civil Design Concepts. What I'll add there is that through the community meetings and conversations with DOT, with county staff, with members of the community, the programming did change. The traffic studies take a lot of time to process, and as you know, they're very large. So what we've done in the latest traffic study, while the numbers don't reflect the exact programming, the traffic study was run on one program, and then there is a statement in the traffic study, and the traffic engineer here to discuss that. There's a statement in the study that says that this traffic study as analyzed is equal to or more conservative than the current programming that is on the applications.
So let's have you step over here and have you sworn in if you're speaking to the substance of it, so the public can know who you are and we can give it the appropriate weight.
Raise your right hand. State your name.
Chris Day.
Do you affirm to tell the truth and nothing but the truth?
I do.
Do you affirm that the statements you've made up to this point are factually accurate to the best of your experience and knowledge?
I do.
Do you swear that they're the truth?
Yes.
Is that sufficient? Continue, please, if you had any more to say.
No, I was just trying to clarify that as these changes have been made to address community concerns, such as removing the vacation rentals, the traffic study, instead of rerunning the complete multi-hundred-page traffic study, we asked the traffic engineer to leave the study as it is, but to go in and make a statement and speak to the fact that removal of the vacation rentals and the adjustments in the programming that are on the application that were submitted were the traffic study was greater, it generated more traffic than what the end-use programming was. And so at that point, we said that the traffic study was a more conservative approach to the actual programming that we were asking for approval, and continued in that fashion. And the traffic engineer is here if there's more detailed questions about that process.
Thank you. Do you want your engineer to speak at this time, or?
Jeff, yeah, I think it might be helpful. Thank you. Jeff Moore.
And if he is going to offer any kind of opinion evidence, that's something we'd want to hear as an expert at the appropriate time. So go ahead and be sworn in first, and we'll go from there.
Raise your right hand. State your name.
Jeff Moore.
Do you affirm to tell the truth and nothing but the truth?
Yes, I do. Okay. When we, the original traffic study, which was submitted to the county back in about the September timeframe, was based on a mixture of uses that changed. It changed and was resubmitted, or it was changed in around the October timeframe to add, to change it down to 42 vacation rental units. The traffic study that I'm holding, which the latest one that was submitted on, it was October 30th, October 31st, based on those 42 vacation units. Those were later removed, and there was a net drop in the traffic impacts from, for instance, the AM peak went from 672 trips down to 638. So there was a net decrease based on the existing uses that we have today. So this traffic study was left, the synchro analysis, the computer modeling analysis was left rather than spend the hours to go through all that as a more conservative approach. So the mitigation, the traffic signals, the turn lanes in and out of the project were based on a higher rate of traffic, and the results we get, the amount of delay, the decreases in delay, et cetera, are based on that higher level of traffic than is what is currently planned today. So we left that as a more conservative with the idea that if we've mitigated that, then less traffic will be even better. So we didn't go through the hours and hours of rerunning the whole study based on that. That's, any questions, anything I can elaborate on?
I'm going to give you a chance to ask questions in a minute of both those witnesses. But do you have any questions since he's technically your witness? Someone brought to your hearing.
No.
Do you have any questions for him?
I don't have questions for either of the witnesses, but I would like to be heard and respond to rebut on the motion to continue.
Let me find out if it's okay with you if we just do all their witnesses and then we can rebut accordingly. And you always have the right to cross them if you express that. I'm going to give you that opportunity for each of those. If you don't want to, we'll see if the next one, and then you'll have a chance to rebut. And you as well on behalf of the city.
I don't think we have any other witnesses. I just want to reiterate that the few amendments that were made between last October 13th and today all went to mitigating the impact of the project on the community. That includes the signalization and pedestrian crossings at the big intersection. It includes, they recolored some of the floodplains so that could be seen a little bit better. And the vacation rentals that we got in our meetings with the public, we got a pretty good earful that the public was not interested in those. So we took those out. So I think my client has tried to do a number of things to respond to the community. This is a quality project, and I'll say again, if we could ever get to the hearing, I think the people in this room would see and understand that. That's all I have, Mr. Chairman. Thank you.
Thank you. I see you raising your hand.
Am I allowed to ask a question?
Not unless you're a party withstanding.
Okay.
We've gone through an hour of that. We can do another hour if you want. But if you're alleging standing, I'm not going to deny you that opportunity.
Pardon me?
Are you alleging that you have standing as well?
Yes.
You do have legal right to speak. I'm a person in the community who lives there. It's a trial. It's not.
Mr. Noor, if you want to go ahead.
I'd be happy to, and I will try to be brief, Mr. Chair. I'll start with Mr. Bissett's statement about this being a quality project. If this is a quality project, it's going to be a quality project on December 11th too. So that's not a reason to have this hearing today. And going back to the changes that have been made, he identified signalization of intersections, addition of crosswalks. It wasn't just a reduction in some of the units that were part of the plan, and I'm reading from page 1 of the traffic analysis that in the original proposal there were 601 mid-rise units, and in the revised there are 655. So there was an increase in the multifamily units in that case. And the reason why that matters is that these different uses have different expected traffic impacts. The amount of traffic generated by a commercial use is different from a storage unit use, which is different from someone's house. And so having all of this information and having it be accurate is necessary for us and for our experts to provide an accurate response. The other thing that we heard from their witnesses was that changes were made and the report wasn't updated. Essentially, they said, well, we just thought we'd use the more conservative approach. We figured we've reduced some things over here. We got rid of the short-term rentals. We reduced the size of the buildings. Our first report must be conservative enough to cover all this. So essentially, their report doesn't match up with the project that they're proposing. All of this is why my clients need to have the time to have an independent assessment performed to provide that information to this board before it makes its decision, and give DOT a chance to do the same thing. So we're asking for a short extension. It's not even 30 days. It is the same that was provided to the applicant when they came in and asked for an extension to get their project right. We're just asking for the same amount of fairness, and we'd ask that you continue the meeting till your next hearing date in December.
I'll invite input from the board. The last question that I had, just kind of as a technical matter, because we've talked a lot about the theoretical of when certain things happen. When were you retained to represent the homeowners association?
I could only give you a general time frame, and then I have other clients as well. I don't have the specific dates on the top of my head, Mr. Chairman. I'm sorry, but I could provide that information to the board if
Ballpark.
Formal retention probably late October for the homeowners association, for Miss Warren and Miss Elkins within the last week and a half. For Miss Corpening, I think within a week, ballpark.
And have you submitted everything to your experts that are going to look at this, or?
So we have had expert analysis, I'm having trouble with my words today too, done on stormwater and flooding. We had an expert identified for architectural review, but that expert had a conflict at the last minute that prevented her from being able to attend today. The traffic has been the most difficult because of the inability of local firms to service that need, and so we're having to go beyond Charlotte to identify firms that would be willing to give us that information. And so it's not just timing, but it's also finding someone who's able to do the work. And as the board knows, these aren't things that a lay witness can just come in and tell you, well, I think the traffic's going to be bad. We've got to have an expert in order to do that.
Thank you. I'll invite board input at this time.
I have a question of applicant. Do you plan to update the traffic study? Or are you going to leave it just as?
We think it has been updated.
Just with that statement, correct?
With that statement, because the issues with traffic are only decreased by the current programming. They're not increased. And that the mention of the 601 to 655, that was just moving the vacation rentals to the normal apartments. And I think anybody will tell you that you're going to get less traffic. I'm no expert, of course, so I may not be able to say it, but you're going to get less traffic from a normal apartment than you are from a vacation rental. So that's going to be decreased. And I know we can have a battle of the experts. But.
And
Be respectful.
just a question, and I don't really want to hear from the audience that much, but when you're talking about community meetings, was it really just the people in your group?
No, we held a community meeting, what was it? At the Crossroads Church.
And they're the owners presently, correct?
Yes, they are. And we held a meeting which we noticed people, we sent notices to everybody within 1,000 feet of the project.
Okay, respectfully, we haven't made a decision. We haven't even gotten to a phase where anyone knows what we think at this time. If I can't hear what people are saying, we're going to have to take a recess just so I can take a minute to be able to hear and fairly consider both parties' positions. Please, please, please let the process run its course.
We also had significant discussions with the Hominy Creek Greenway people. And so it's been an ongoing process for some 10 or 11 months now.
Were there any of the deadlines missed, or there's an implication of that, but I'm not sure.
For clarity, can staff say, were there any deadlines that were missed per the ordinance or other county regulations?
No, all deadlines were adhered to.
Mr. Chairman, you still entertaining board comment?
Please, yeah.
I mean, this is tough. I mean, we have a huge number of people here and upstairs. We have a significant amount of time that has been invested by the applicant. This has continued once. I will say personally, I'm not looking forward to thinking about this more, but we are supposed to judge what information has been provided and if the ordinances have been met. For me, there's significant confusion as to what this project is, as to what is listed in the initial submission and what is in the second one. I have an updated plan that mentions vacation multifamily. I do not know if that is the final plan, if what is in the original traffic impact analysis is the final plan, if what is in the revised one is the final plan. I think there have been significant changes made to the plan, if nothing else, the signalization. And I don't think the entire concern is whether the traffic impact analysis reduces it from what it was in the initial iteration. One of the things that we have to consider as a board, and I think that all of the neighbors have to consider, is whether this meets the conditions of our ordinances. And if they're not granted enough time and understanding whether they're single family, whether they're vacation rentals, the size and the scope of the commercial, the size and the scope of the mini storage, in essence, what the plan is, I don't know how they, and I don't understand how we can look at this and say, does it meet the conditions of a conditional use permit on that? So for these reasons, I would be supportive of a continuance with hesitation, because again, there's a tremendous amount of time and effort that has been put in this, but I would look that a final plan of what is to be proposed is presented 30 days in advance so that members of the board and so that people that are thinking on this and oppose this, when that's updated on the county website so that we can see that, so that we can understand that, and then that information is presented in a public hearing such as this, and this quasi-judicial hearing, that we can look at it and know what we're dealing with.
Any other board input? Robbie?
I just have, I mean, I have a hard time with it since all of the conditions were met, all of the timelines were met. It is hard. You have so many questions in your head. But then, I mean, y'all were at the last meeting as well. I was not. But, so you knew it was gonna be continued, but you've just now been hired. And I guess what I'm saying is that it's hard, since all the timelines were met, what's gonna happen if we get back again next month? Are we gonna say, oh, well, the DOT's not here, so we're gonna continue it again? I guess that's my question is, do we just keep going?
They had 11 months, we just found out.
But it was at the board last month too. And like I say, I don't know, and I'm just saying that we have certain parameters that we have to meet, that we don't have any other choice. We have things that we're told, and I guess I'm asking is what's going to, are we ever gonna get to that point where we go ahead and hear it?
Well, I actually read and study over the traffic studies and those plans, and as much as is given to me, I consult that, and I think I do appreciate what you said about how it's generally this or mostly that. But I think we should have the specifics. If it's a change, we should get the change, because we actually do use that to study up on the thing, and I would feel more comfortable going directly to the hearing if I had the review. In other words, the traffic study was revised to show whatever had been changed.
Could I respond to that? I was just asking if, if that takes a few days, does that then throw us into January? That's the kind of thing that is concerning to me. Now, we know what's in the project. The county staff knows what's in the project. So, I'm like Ms. Taylor how long is this gonna go on?
If I might just provide a brief response.
Please.
He identified the county and the applicant. Well, we're the community, and we're saying, hey, we want to know what's in there too, and we want to make sure that this report is right. And we want to have the opportunity for our expert to look at it and come and give you opinion on that too. And the report should be right. That's what y'all are making a decision on. You've got conditions to meet, and you need to look at the evidence, and you need to make the best decision you can. And you can only do that when the information's right. So let's get it right. Let's give the time necessary to do that.
Mr. Chair, if it pleases the board, something that may help the board understand is, one, the county doesn't maintain roads. The DOT maintains roads, and there are some in the city of Asheville, which the city has control, which is why you have the NCDOT present at this hearing, as well as the city of Asheville. It may be helpful to understand and hear from the NCDOT so as to understand their process. We do have a provision in the ordinance that says you must submit a traffic study to the county if it's greater than 75 units. That's not a commercial floor area threshold, that's a unit threshold. So that part's done. However, you need to hear from the DOT as to their methodology. They have sort of a three-step process, so it might be appropriate so you understand where they are in their next steps as they correlate with the decisions you may be weighing right now.
I don't see that as prejudicing either party. If more information is better, then I don't have any opposition to hearing the DOT.
I don't have an objection
Thank you.
as to their process.
Mr. Edgerton, for formality's sake.
No objection.
So we can either, I can hand this over to them, or would you probably want...
If you don't mind coming up, and just make sure we do it right. Unless somebody has an objection to 5 more minutes at this point. You just state your name for the record and be sworn in prior to speaking.
Timothy Anderson.
Raise your right hand. Do you affirm to tell the truth and nothing but the truth?
I do. So, to speak to our process on a driveway permit work, a typical commercial driveway permit.
Sorry, who do you represent?
Oh, I'm with the Department of Transportation. I'm the division maintenance engineer. Currently, our district engineer, who ultimately signs driveway permits, is on paternity leave. So I'm standing in for him today. So we have received the TIA as far as, with this development. And our process for the department, we meet with the developer. We determine the scope of the TIA, what intersections will be reviewed, what counts, what distributions. After all that's done, the developer generates the TIA, submits it to us. The department reviews that TIA for completeness. The deadline for that review is December the 2nd. And at that time, we'll respond back to the applicant, whether it's or their engineer, whether the applicant or whether the TIA was complete. And if it's not, then they'll be responsible for making changes. If it is, it'll be moved on to technical review by our congestion management unit in Raleigh. That unit will have till December 22nd at the earliest date will be their deadline for the review. Back to the engineer, whether we concur with recommendations, have other recommendations. So at the earliest deadline will be December 22nd for us. Have that information back to the developer for what final improvements are required.
December 22nd.
That's correct.
Mr. Chair.
If you can have 1 moment, if you don't mind. Does the board have any input prior to me letting counsel speak for either side? All right, Mr. Nor, go ahead.
I just had a couple questions for the engineer. So for clarity purposes, your assessment or your review is not complete yet for this TIA on this project.
That's correct.
And your next step is to just determine, well, do we have everything we need? Is it complete? And that is not complete. That won't be done until December 2nd.
That's correct.
And then after that, congestion management, which actually looks at the kind of the substance of it, does a review in Raleigh. and that is not going to be complete until December 22nd at the earliest.
The deadline would be December 22nd to have the information back to the engineer. Could be a little earlier, but the deadline for us would be December 22nd.
And in that context, you all could ask for changes to be made based on the TIA to deal with what's being submitted, correct?
That is correct.
And that might change the plan on the traffic impact as well. Or it wouldn't change the traffic impact, but it would change how the configuration of any mitigation that was required might be incorporated into the plan.
If there's not concurrence on recommendations from the developer's engineering firm and what our unit in Raleigh reviews, there could be changes.
Okay. But at this time, DOT doesn't have their review complete, so they don't know whether there'll be changes or not, or whether everything has even been submitted that's needed.
Right. That is correct. We do not have the final review completed at this time.
Respectfully, just so I have clarity and the public can be involved in the transparency of this process, is there anything irregular about this process in our normal hearings? DOT has their own process, separate and independent from what we do here. To be candid, you're not a county employee. You're not. I'm not going to. Could you explain a little bit about what his role is in
That's
this?
correct. So it gets back to that whole conversation about when folks submit for an application for development, it's with the understanding that additional permitting has to go into it. You all are not a permitting body. You are a reviewing agency and ultimately an approving or denying agency. It's up to staff and all the subject matter experts, and it could be multi-departmental, multi-jurisdictional. Think about the Army Corps, Department of Environmental Quality, NCDOT. There's numerous things that have to go into a project after, say, it's approved. And any one of those agencies, there could be a hurdle that may prevent a permit ultimately from being issued. Like the DOT, your approval is not going to say the DOT is going to actually issue a driveway permit. So just keep that in mind, that essentially at your point, you're looking at a site plan based on layout, footprints, those sorts of things. But just like the outdoor lighting, you're not looking at a detailed outdoor lighting plan. I wouldn't wish that upon you.
And I thank you for that. I do want to say to both parties prior to anything you say going forward, and I'm not going to stop you from speaking by any means. I'm a big proponent of attorneys being able to argue what they want because I do it the other 4 days a week when I'm not here hanging out with you guys. But to the extent that we are the Board of Adjustment and you both know what we do regularly, we're not in charge of the engineers. We're not in charge of it. And I'm going to be candid with you. This traffic, every person on this board can tell you, has been a huge concern for every single project that we've looked at. But in the grand scheme of what we can and can't consider following the ordinance, and you all are very familiar with it, it cannot be, and often is not, the pivotal determination for us in approving these projects. The ordinance is much more complex than solely a traffic study. So if that's the only portion of it that we're arguing over, I'd like to have a little bit more expansive discussion because this is not uncommon at all. And you've presented here plenty of times. Both of you are very experienced attorneys. There's nothing unusual about this. The DOT might have something else happen. They will be pushing this out to February, waiting on experts from both sides to approve, look at things, not approve. And I hear that. I'm not saying that I'm taking a position on one way or the other. I just need to hear more than just the traffic study because that is the number one thing we spend about 2 hours talking about most times, and then ends up being not inconsequential, but certainly not within the parameters of what this board can consider because we're not the permitting body that handles the traffic portion of this per se. Is that fair?
I think that's very fair, and I'll be brief in my response to that. Is in certain circumstances, in a lot of cases, traffic may not be the impacting factor, but the conditions, one of the conditions that you have for deciding this permit is a condition that the project not be injurious to neighboring properties. Traffic can cause that injury. It may not in every case, but it can, and that is one of the explicit provisions in the conditional use standard to decide. And in this case, and I'll use an example, if DOT were to come and complete its review, well, I'll back up. One, DOT was asked to come today. Is that correct?
That's correct.
And I think that was by the county planning staff because they thought DOT might have something substantive to contribute to this discussion. So if they were asked to come today because their opinion would matter in your decision-making process, I think we need to let them finish forming their opinion.
But
As part of
I
that-
guess, to be candid to everyone here in the room so that everyone knows what's happening, these things are approved and not approved all the time without the DOT having reached their conclusion, and often are not. Not because the board isn't doing its job, but because the DOT process could take, they might not start building this thing for another 6 months and not be done with them for God knows when after that. So I hear you. I'm saying, take me to the next step in terms of what else we're considering beyond solely the DOT concern. That's the only thing that we have, and that's a process issue. And you're not going to get any disagreement from anyone that on this board that government can be inefficient. That's
Well, DOT is one part of this, but as I said earlier, we are entitled to the opportunity to present our evidence in response to this application. And that means having the opportunity to have our expert come and put forward their response to what's been proposed. And traffic is a component of this. And it has the ability, and in our opinion, will adversely impact the value of neighboring properties, some of which are owned by my clients. And so having that opportunity in the continuance context is exactly what we're asking for. That is independent of DOT's review. Now, we think their review is important and impactful on this project. And if they were to recommend additional mitigation strategies, that would change the impact. But we don't know whether that's going to happen until they complete a review. We've also not asked that this be continued beyond DOT's review. That's not what we've asked for today. What we asked for is give us until your next meeting to have our opportunity to get the expert we need in here, independent of DOT review. And we're not planning on coming in and next month and saying, okay, let's have another continuance, let's have another continuance, let's have another continuance. That's not fair to the applicant. We're not trying to do that. We're just asking for the same amount of fairness that was extended to them last month to make sure we can provide the information we need to.
Thank you. Would you like to respond to that?
Well, I would just say that the process that's taking place in this application, in my experience, is the one that's taken place in, as far as I know, every application. I don't know, I'll ask Planning Director Pennington, how many of these application hearings have you gone through where the developer was required to wait to get the final approval from the DOT? I don't know of any. Of course, you've been to a lot more than I have. So we've done what is normally done in the submission of our plan to DOT. They've approved. We've got a letter approving the scope of what we've done. And on top of that, they've been in meetings with both our traffic engineer and the City of Asheville traffic engineer on numerous occasions in the last month. And as far as I know, everybody seems to think that this is a great impact, which will lessen the impact of this project, this signalization project. So that's all I have.
Just one last thing. Mr. Bissett's response that they have a signed scoping request, I think that kind of goes back to the points that were made about this document. If you look in Appendix G to this TIA, the traffic impact analysis screening and scoping request, there is no signature from the NCDOT representative in the version that was submitted to you. So until we got here to suggest that the scoping has been agreed on, it's not in the report. And I think that goes back to, let's make sure the report's right. So again, let's give the time for this to be done right. And this is not the usual project.
Right.
So like every rule, there are exceptions. And in this case, you have the discretion to give additional time to the parties so that you have the best information in front of you when you make your decision.
We still have time for board input.
You know, this is a really.
May I?
You may.
All right, thank you.
This is a really complex project, and there are so many hurdles to go through. You've got flood mitigation, there's so many other things. The chances of you guys being back here one way or the other is pretty high. As far as the continuance now is concerned, I think, seeing as you met all the criteria, I kind of wanted to do this today and see you again down the road when something comes up.
Won't that be fun for Christmas?
It will. So I'm not really supportive of continuance unless, of course, the applicant decides that, in fairness, you want to do it.
I have a question. sometimes things come back to the board after approval if there were changes. Could you speak to that briefly?
Sure. Oftentimes, this board has specifically seen, let's use an apartment complex for an example. You've approved a site plan for an apartment complex in one format that might have 10 different building footprints and a circulation plan and parking and buffering, and say they get out to the site, and this goes back again to the conceptual site plan versus real world conditions. When you get out to a site and you do some geotech borings and you find you hit solid granite. So you've had any number of site plans that have come back where there's been the addition of a building, deletion of a building, a change to the layout. Staff is very limited as to what we can approve, and typically what you find in ordinances across the United States is a language that might speak to like a 10% or a de minimis change, but you've often seen changes that come back to the board for real world conditions that pop up when you get into the trenches with permitting and having to change things around.
In construction.
Yes.
I just feel that on a project that's this important, and it's important to everyone, that more information is better than less. Accurate information is better than a generalization. And as a board, we should make sure on something of this magnitude that every T is crossed and every dot is on that I. So I support the continuation. It's not unreasonable. It's 30 days.
I want to be clear. We're not talking about a continuation until the final DOT, because
No.
that's what you kept saying
The next meeting.
about, and you're talking about continuation just till the next meeting.
Right.
I'm supportive of a continuance today. I think it's important for the public, important for us to have all the information we need. I think we have new movements today who are present, and that's a new development today, and we should give them an equal opportunity the applicants have had to prepare their case.
At your convenience.
I'm supportive of the continuance. We have a lot of people, and they may not have been included in the hearings, but they need to talk with an attorney, their attorney, to see if they have all the facts before it comes back to us. So therefore, I move for the Board of Adjustment to continue this meeting until the December meeting of the board.
Can I add one stipulation to that?
Please.
I'm getting a feel for where the board's at. I'm not going to do anything to change that. I would say that regardless of what decision we make, if a continuance is on the table, then kind of as the court parties are familiar with, marking it last. This is, to be completely fair, the DOT may take forever and a half. I don't have any strong objection to continuing it, but I will say the number of people in this room and the number of people who are not in this room is showing a legitimate community interest one way or the other. If we vote to continue it, my amendment to your motion or request
Please.
in your motion would be that we hear it on that date certain and everybody have everything ready to go. So we don't wonder which parties are here this time, which ones aren't here next time. Two of your witnesses might be unavailable next time, and that's a substantial impediment to everybody involved. I don't particularly care one way or the other about money being involved one way, but I do think there's a prejudice element to both sides when there's not a date certain on any kind of court matter, because everyone's rights are affected here, developers and community members. We all agree to that?
And my motion will include his amendment.
Okay, Mr. Chairman, can I respond to your question? Because that's something I've got. I mean, you know, if, I don't know how many days it is between now and your December meeting, if we get our final, whatever we're supposed to have numbers in 3 days from now, I don't want Mr. Noor coming back and saying, well, you know, we hadn't had that for 30 days, so we need to go to January.
I won't
So
do that.
that's one thing.
Not a 10-day hurdle?
So
Supposed to be.
let's go over a couple of dates. First of all, let's be really clear in our motion for the continuance that would be to the December 11th, right?
Yes, sir.
December 11th would be the next hearing date. This would trigger staff to send out notices within 1,000 feet and also repost the property, which we did again because the signs went missing. So we will repost the property with new signs for December 11th and send those notices. That will also trigger, and we'll do this just because. We're going to go ahead and put out a notice in the Asheville Citizen Times as well, and we will update the website. I assume that probably we need to land back in this room because there's enough public interest. So we will do that, and we'll do a special little box to call folks' attention to this as well.
All right,
Go ahead, I'm sorry.
so, if, for instance, we posted these things Friday, meeting it without objection on the 11th.
I would ask that question to both attorneys present of each party, but that in your motion, you absolutely have the ability to, as a board, continue the item.
As for myself, I personally think we're gonna be back in one way or the other, so if we're gonna approve a motion to be here on the 11th, I support it.
Do you second it?
I second it.
Mr. Chair? Yes. I think we'd like for you to do a roll call vote on this one.
Fair enough. I have a motion and a second. We will go ahead and have a roll call vote. Let's start from right to left. Sorry to put you on the spot, Robbie.
I agree.
All in favor? Are you in favor
I'm in favor.
of the continuance?
I'm in favor.
With your addition.
With the understanding that it's to be marked last, not to be continued again.
Correct.
In favor.
In favor.
In favor.
In favor. All right. Just a heads up to all parties. Regardless of what's going on, we're not going to continue this. It's not fair to the community. There are lots of people here to speak. I don't know what they're going to say. I have a pretty good idea from how much yelling there is. But I think it does impede the process when we have people shouting out, people bringing posters. So if I can request, to whatever extent people are watching right now and whatever extent you guys have control over that, please let them know that due process, fairness, and a decision that sticks and isn't going to get appealed to the Court of Appeals or whatever down the road, or Superior Court, then the Court of Appeals, is kind of predicated on the idea of both sides having a fair opportunity. And I think that that's best accomplished by having the hearing next setting. Everyone have all their experts here, everything ready to go. We're going to make a decision one way or the other, and I would encourage everybody just to be prepared on that day.
Mr. Chairman, can I ask one thing? Could you ask or direct Mr. Noor and the city attorney, since they get to see all of our reports, I think it would only be fair if when they get their traffic report or their lighting report or whatever they get, that they be required to submit those to us for our review before the hearing. Otherwise, it gets sprung on us the day before. And that's not the situation in our case because they've had it for a long time.
I'll be honest, to the extent that I have any power, I will say that I would give great weight to the understanding that if one party is not seeing the other side's expert report ahead of time, that puts someone in significant disadvantage of cross-examination and otherwise, and leaves you without real opportunity to have a discussion other than us just having two experts get up there and battle. So for whatever that statement is worth, I can't order you to share it. I think it would be advisable. I don't really see how it would hurt anything on your side anyway.
We absolutely work with Mr. Bissett and Mr. Ost on that, so that
Thank you.
doesn't become an issue.
And yes, final matter, now that all of you probably know who we are a lot better, my name is right here. For the sake of the process and not disqualifying members who might otherwise make a decision that will help or apply the ordinance in the most fair way, please do not try to independently contact or send anything, and that's inclusive of city officials and otherwise. Impedes the process, we can't consider it. Anything you say is really just going to kind of prejudice consideration, and we might find ourselves in a spot where we can't even vote on it. So if we can have that for a solid 26 days, I think we can get this done in the next 7 days. Thank you.
Thank you very much.